A federal appeals court battle could have serious consequences for the internet. At stake, whether people can post anonymous comments or even negative reviews of businesses. Jan Crawford is in Washington. Jan, good morning.
Good morning, Charlie. Nora, everyone has always thought that owners and operators of websites like Facebook or TripAdvisor or eBay aren't liable for their users' comments. People get on there and just say whatever they want. But a ruling by a federal judge in Ohio in a really strange case involving a former NFL cheerleader and a gossip website may suggest otherwise, and the internet giants are fighting back. The legal fight started when a website called thedirty.com posted anonymous false comments implying that former Cincinnati Bengals cheerleader Sarah Jones slept with the entire team and had not one but two sexually transmitted diseases. When the website's owner refused to remove the posts, Jones sued and won $338,000 in damages. But what started as a fight between a cheerleader and a gossip website is turning into a major battle over internet freedom.
This case has the potential to make websites basically no longer be able to allow users to say anything they want to.
And that's why the nation's top internet companies are urging a federal appeals court to set aside the decision holding the website liable. They argue the decision, the first of its kind, could force them to change their business models or curtail their services in significant ways by restricting third-party comments, negative reviews, postings, or tweets.
If a website owner is responsible for what a user posts, they're going to really restrict everything that users submit.
But Jones's attorney, Eric Dieters, said this case is different because the owner of thedirty.com acted as an editor, selecting which submissions went up on the site and even making comments of his own.
If you just provide a platform where people can post, you don't have nothing to worry about. If you actually control what goes up, what goes down, and edit it, you got a problem. You got to make sure that you don't republish defamation.
Now, the cheerleader is going to file court papers by Friday, arguing that her case is really narrow and that these big websites and social media platforms like Facebook or TripAdvisor, don't control the comment, that people can just put up what they want. So the appeals court then, of course, is going to be hearing arguments in this case, Charlie and Nora, probably early next year with a decision in the months to come.
And Jan, do you think this has far-reaching consequences for all organizations?
Well, I think it could on these kind of websites where you weigh in and put comments. That's why this is such a huge issue, because federal law typically has been thought to protect that and protect websites from people. That's why the internet's had this vast, billions of users weighing in with this free form exchange of information. So this is kind of seen as a big test case, and whether or not the courts are going to see it as narrow, like the cheerleader says, or big, like AOL and Yahoo says, that's what the federal appeals court is going to have to decide.